Well, all right. Took a week off because I was moving to a new place, and at the same time it was being renovated. So if you see this in the back, that's how good it looks so far. The rest of the house is a mess, but I managed to frame a little space to do this video. This is a thing I've been doing and talking about for a while, at least 7 videos. The concept of securitization, which is just the word alone, it doesn't seem like it's something you want to watch. I'll probably do a 10-minute video, and it probably will be 10 minutes. But securitization is really something that's been out there since, well, at least from the debt collection prism or perspective, 2006. That's what happened to this country with the mortgage crisis, with a system called mortgage-backed securities, where anybody that had a pulse was financed. And if you're wondering why they did that, because they wanted to get as many loans as possible to package into securitized trusts that then they could sell the bonds as an investment idea. And there was some issue as to certain ratings companies giving debts that were just awful AAA ratings, so people bought into buying these bonds, and then when those people didn't come through with their mortgage payments as the economy got worse, everything defaulted. It all stems back to the concept of securitization. Really, debt collection law firms said, hey, that's a great idea. Well, debt buyers, there's very few debt collectors and debt buyers. There's Midland Credit. The law firm derivative of Stenger and Stenger is buying debt. So are other debt collectors. But the major ones like the PRAs, the Crown Assets, the Midland Credit Management, they're buying large swaths of debt. And if you're being sued by them, when you understand the concept of securitization, it's all BS. There's no way they can own the debt. So separate from all the perfect defenses that you have as far as the chain of title and proving that an assignment doesn't exist, the overall umbrella of all that, and it's the foundation of securitization, is all debts are securitized, whether that's receivables or the whole debt is sold, which is usually in your personal loans, where you go online and maybe Citizens Bank or Cross River Bank is another favorite. Velocity buys a lot of that stuff. Upstart Network is a huge one. There's a bunch of large funding companies that are initially funded by a securitized trust. They take the money, they lend it out. Then the originator, that's the person that lends the money out to the consumer, the original creditor, that's where that word original creditor comes from. The originator sells it to the securitized trust for a discount, who sometimes allows the originator to keep the rights to collect the debt. But the overlying concept is that the debt no longer belongs in the person or the creditor that is suing you. Whether it's Citibank, Wells Fargo, Bank of America, they all sell off their debt because, like you and I, when we want to get more credit, we have to, especially with a house or a purchase, our debt to income ratio has to be low for us to get the best credit rating, in their case, from the Fed. So they get rid of that debt. And if it remains on their bottom line, their balance sheet, their debt to income ratio, just like you and I, is out of whack. So they have to sell it to what's called a bankruptcy remote special entity. I know this is going off the rails already, but this is where it's at. And once you get it, man. Once that entity owns that debt, it's not on, for example, Citibank, who we're going to use today as an example, bottom line. So their credit rating goes up and they get more money to give to you and I, to securitize the debt, to give the trust, to get more money. It's a big circle, And as always in America, it's the little guy that suffers. One way to suffer is be subject to a lawsuit. Two things. Again, this is being given under the auspices of the education and information and somewhat entertainment value. Plus, again, this is a S-storm back here. You can barely see it. It's a mess. So I'm here to help, but I'm not counseling you on how to operate. I'm telling you what I do. By way of background, when debt buyers sue my clients, it's an easy thing to get my clients out under the right conditions because of who I am and all the work I've done over the years. They just stop dealing with me and just give me what I want. If it's not too something outrageous that I'm asking, nothing is if they don't own it. So then they'll eat the debt, the lawsuit goes away, and the client is happy. That's an easy thing in debt buys, because debt buys, as I've always said, if you went to my how to defend against a lawsuit, a debt collection lawsuit, you'd hear the concept of pennies on the dollar. How to defend against a debt collector, pennies on the dollar. Debt buyers buy these things for pennies on the dollar, so they'll eat them all day long rather than suffer the litigation costs of dealing with a whack job like me. Okay, I've put myself down, that's it. So I do that once every video. Unlike debt buyers, a company like Citibank is the original creditor, the originator of the debt that's going to get securitized. So from an FDCPA standpoint, the Fair Debt Collection Practices Act, which myself and attorneys like me operate under against debt collectors, they are not considered debt collectors. Therefore, they're not under the, if you will, this word, auspices of the FDC regulation. So you're rather limited on what you can do to beat them back. You're just, at the best, settling a debt for a client. And I never feel comfortable about that. Most clients are happy you knock off $3 to $8 grand or whatever. I'm just intrinsically, I like to get the debt eliminated. It's a challenge for me, and it benefits my clients, and I know I'm nuts in that regard because it's not my debt. What do I care? But I do. I like offering my clients an elimination of the debt, and it can't happen generally against a Citibank or a Wells Fargo or a Bank of America that are the originators. Now, I'm going to keep repeating myself, I know. You might get a little sick of it, but it's how I do it with juries, and eventually they get it. And again, as I've said before in my how to try a jury case, if you do it right, you can actually see the juror members, the jury, will voice the words as you're saying them. And when you see that in a jury trial, you kind of just won, because that's who's going back. Hopefully they're the foreman of the jury. So I do repeat myself for your benefit, not because I'm I have Tourette's or something, among other things. So the concept of securitization is a newer and very much ignored defense in a case where I can't get my client out of the whole debt. And you'll get the law firms you're opposing are really hard asses when they know they've got this kind of debt. They won't put up with any nonsense. So it's been a hard slog, but it's starting to work. So what is securitization? Securitization is simple. An originator, again I said the originator, which in the FDCPA, the original creditor is called the original creditor. So out of that FDCPA prism again, the original creditor, the originator of the debt, will say, sure, you're applying for a credit card, we'll give it to you. You got $1,000 in balance. When you sign up for that, they sell that debt. As I said, remember we're talking about they need to keep their balance sheet low so they can borrow more money. They sell it to a trust that they've set up. For example, we're going to use a Citibank lawsuit today from a law firm called Stinger & Stinger. That's their baby. I don't know if anybody, at least in Michigan, represents Citibank as well as they do and as prevalently as they do. So we'll look at one today, and as I've said in How Do I Defend a Lawsuit or How to Try a Case, there's a way to look at the lawsuit. But before we do that, so securitization, you're taking the security of the debt, and minimally, the originator is selling or transferring its, if you will, servicing rights or receivables to the trust, who then mixes that with millions of other deals and sells bonds on the, usually Moody's or someone will rate all of these bonds saying, hey, it's the same as the mortgage-backed security. The debts that are in this specific branch or tranche of a trust or the whole trust are AAA rated because all the people had at least a 650 FICO score. So bond people, go ahead and invest, you're safe. It's at least B plus, AAA, and you'll get X amount of dollars. So if you're in a trust where there's 550 FICO score, now that risk is much higher, you're paying less, and the reward is good if people don't default. The economy can have a great impact on that, and there's kind of several kinds of tranches of these debts. So generally, credit card debts are not that long term, 3 to 5 years if that, because someone's going to pay them off or somebody refinances, boom, that's the first thing that goes. So there's an allowance, in this case, let's say it's Citibank and Citigroup. Citigroup is the one that puts the trust together. I think it's even called the trust. So by virtue of the fact that Citibank is suing you, but Citigroup is doing all the securitization, that is a hint and a half that clearly Citibank never had the right to sue you just on that alone. Why is Citigroup involved? They create this trust, Citibank gives it to them, gets it away, bankruptcy remote, out of their bottom line. And now that debt sits there paying the bondholders that are paying the money to the trust, that in some cases pays the originator that goes and lends more money, that gets people like you and I to sign up for a debt, which they then sell at a discount to the secured trust. I keep repeating that same circular nonsense, so you'll get it, hopefully. And I will continue, this is boring, to show you what I'm doing. And what I'm doing is, if someone is suing you and they're a creditor, they are not covered under the FDCPA. However, a couple of things are true. You can make them a debt collector if they've securitized the debt. Why? The definition of debt collector is a third-party entity collecting a debt owed or allegedly owed by another, and they're collecting it for a third party. So that's I'm kind of convoluting what the definition of a debt is and the definition of a debt collector and a little bit of a consumer. But essentially, when a third party is collecting somebody else's debt, they're debt collectors, and the debt is in default. And even if someone doesn't owe it, but you allege that they owe the debt, that is covered under the FDCPA as a debt collector collecting a debt. So when Citibank sues you, they're not debt collectors. We're the creditor. We signed the person up. But they've securitized the debt. Meaning, what have they done? They've gotten rid of it, and they have to sell it in a way that it won't reflect on the balance sheet of Citibank. So they've sold it in effect. So if you see Citibank suing you or your client, they are collecting as a third party. Who are they collecting for? The trust. In this case, Citigroup. So I am coming in now, and then I say, well, if Citibank's a third party collector, in my eyes, because they're collecting upon a securitized debt, that's the definition all day long of what a debt collector is. There are some debt buyers that are clearly debt collectors, could argue, no, we're really just the original creditor, where you stand in the shoes of the original creditor. And we shouldn't fall under the FDCPA. I just gave them a hint, but they won't go that far, and there's reason. So Citibank can sometimes be more of a debt collector as a creditor, really, than an actual debt buyer who's bought it 6 owners down the road. I'm getting really complicated. So I go in and I sue them as debt collectors. It drives the law firms and Citibank crazy. But just about all debt is securitized. So taking it another way, even debt buyers, let's say D&F, that's a big debt buyer, D&F and Associates. They buy old blah, blah, blah debt. Citibank, Fifth Third. Fifth Third Citibank has sold it off in securitization. So even on a debt buy level, they're buying, and they'll go, look, I've got the assignment. Well, I can beat that without securitization. But one level over, I don't have to even say there's no assignment, but I will, because I'm not going to stand down off any defense, because this thing got securitized way back when Citibank had it, before 5 years later D&F bought it. So this securitization has many levels of rewards for you if you just do a little bit of work. It's going to be hard, and then it's not going to be hard. It's about, you're benching about 180 pounds if you lift this stuff. But eventually, once you're benching 180, you can go to 185, 190. So you're benching some heavy weight here. I put the time in. If you're an attorney, the rewards will be fabulous. What are the rewards? I'm getting better cases, better settlements now, since I brought in the concept of securitization and treating the Citibank as a third party. A lot of the firms are going crazy and bringing in extra firms to really fight me on this, because if I'm right, which I am, which you will be, because you're going to put the time in. I'm already loosening the cap for you. This will be so rewarding. This will be better than suing debt buyers if you stick with it. How do I know that? Because of the way they're fighting me. I have never had a case in 30 years where a debt collector that's defending against me said, we're doing a motion for arbitration. My clients will do that on their own. I don't. I'm starting to get that now, where they're saying, and this is after discovery's done, after 2 pre-trials, after litigation, a counterclaim, this is all going along. Then suddenly they're going, uh-oh, we need to arbitrate this. I've never had that before. Now I'm getting it. I'm getting incredible deals just to go away. I've never had that before with a creditor. Now I'm getting it. I've had a couple of law firms say, we don't even want to get into this, we'll just eat it. And I've never had that before, where they just eat a credit card from an original creditor. That's happening with this securitization. So there are riches here. And I want you to go and start pushing. If you're not pushing, you're not learning. If you're not pushing, you're not getting better. Again, it's the weightlifting concept. I lift heavier and heavier as much as I can. I'm getting older now, so stuff's starting to break. But I'm not going to get bigger or maintain unless I keep pushing and pushing. It's the same with the brain. It's just a muscle, man. And it's got a lot of on-top tapped energy. Mine does. But I tap it. And I want you to look into securitization. So very briefly, I'm going to try to do this old school. I'm going to show you on my notes. It's going to say Citibank answer notes. And I'm going to tell you, I'm just going to show you now, but I'm going to have it edited into this. And how, if you looked at my how to defend against the lawsuit, collection lawsuit, I'll tell you what I do. This is what I do. So I look at an allegation. I say whether it's true or false. If it's true, it'll go on this side. Sorry, I was pointing up here. If it's false, generally they all are, it'll go on this side, and then I'll say false NP, no proof. And I'll write that down, and it's usually an 8-paragraph lawsuit, void of any proof. And that's how I start a trial, defending. Every case I work on begins with this. I can do the stuff in my head now. I can do it on cases I can't even see. I'll just know my client's being sued, and I'll start doing that. You will too. And then I will file my answer, which I'm going to again put this, it's in my notes, in my Podcast Plus show notes under Citibank Securitize Answer. And I'll do a preliminary statement. And in that preliminary statement, I'll talk about and add to, here, one of my attachments is, see attached Citicorp's own financial report showing the credit cards are securitized and off the balance sheet as an asset. Remember what I said, always be closing with judges. They don't have time, nobody looks at an answer, and it's usually admit, deny, I don't know. I don't do that. Put the extra effort in and it'll save you time down the road. It'll settle the case. It'll tell the judge, it'll tell the other side, uh-oh, because most of these debt collection attorneys, they're not in it for the effort or the work. They're in for the paycheck. It's maybe their first job or their last job. It's not an area you go to do great things. I admit that. I could be doing medical malpractice or personal practice. This sticks to my brain and I go dig, and I want you to go dig. There's tons of good stuff where you can intellectually satisfy yourself and help your client. So I have a couple of pages there telling the court exactly what's really going on from my side of things. I got to tell you, courts are looking for a defense. They don't want to default their constituents. They don't. They do want to move cases along. And so right now I'm going through the hard work of introducing into, again, what's called the concept of securitization. And it's really easy. It's just a third party that owns the debt that Citibank, which is normally a creditor, the originator, is just collecting as a third party debt collector. And Stenger & Stenger makes it a lot easier. I'm going to, again, put this right in the video, but I'll do it here. Down here they say, we are debt collectors. Anything you say will be used for that purpose. Well, Stenger & Stenger is not in this lawsuit. It's only Citibank. So that means they're admitting in a pleading that they are debt collectors. Why are they doing that? I tell the court why they're doing that. Because it's the only way that it's securitized. So I've gone at it really hard, and they're starting to come back and fight me on this. And their latest defense, you're going to have to start lifting 190, 200 pounds on this one. But there's a pooling and service agreement that governs, it's a large umbrella over every trust done by a ton of New York lawyers that create the contract between the secured trust entity and the minions or the buyers or whoever it is that's selling them this debt that they're securitizing. You better believe it's full of tons of legal protection language. But it says, we will buy this debt, we will securitize. Again, I counsel everybody, just pull up one of these documents or any document and press Control F with the word securitize or secure it. Don't add the E or the A or the Z because you may cut off possibilities. You'll see for the first time how important securitization, when you see how many times the word is used in all of these debt buying documents. And they'll say, yeah, we're going to take the debt, we're going to buy it, it's going to transfer. So correctly, they're defending against me by saying, but when something defaults, and it does say this in their pooling and service agreement with the SEC, there's a service online. Just look Edgar, EDGAR, SEC. And you'll find any pooling and service agreement that governs all of this stuff. It's easier than it sounds. And they'll say, yeah, we buy that debt, but we send it back to the originator if there is a default. I'm defending my client because they have defaulted. So that's a true statement. But if you look into it, they'll say, yeah, Citibank has it back now. It's automatic. But then they say, see Form XYZ for the assignment that you need to send it back. There is nobody sitting offshore in a New York law firm waiting for Bob Smith's debt of the millions of debts. Okay, I got to do an assignment for Bob Smith, send it back. So it doesn't happen. So when they come at me saying, The language says we send it right back, so Citibank should be suing you. I'll go, all right, just send me the assignment, and then I'll send them their own document saying, see, it says you have to do an assignment. Never shows, because it doesn't exist. No one's challenged them this deeply, and there's probably greater depths to go by someone much smarter than me. I'll catch up to much smarter. I just have to work harder. I'm like a Geo Metro compared to the Lamborghini of you all out there. But that Geo Metro is eventually going to get there. So dig in, man. We're all warriors on this. Let's help each other. So they're going to say rightly that they're supposed to send the debt back when your client defaults. So Citibank does have a right to sue you, but they have to show the assignment. By the way, when they do that, and this is a lawyer thing, they just admitted that it was securitized. So what are they doing fighting you 3 motions to compel down the road? Now their argument is, okay, it was securitized, but we sent it back. Hold on to that admission. You'll use that in every other case, because remember Parker's rule, you're always arguing 3 cases, 6 cases down the road. You're going to have another one of these Citibank cases. I got tons of them. So your answer will have a preliminary statement of 2 or 3 pages introducing the court to the concepts of securitization. And I also cut and paste the words, we are debt collectors. Now, Sting is going to show up at the pretrial and go, yeah, that's just us. Well, FDCPA, sorry about that, 1692E11 says don't do that in a pleading, which they do the opposite. They do it. So are they admitting they're breaking the law, Your Honor? No, of course not. So this is, they're not in the party. So in the they're not one of the plaintiffs. So Citibank is a debt collector according to this. If they're writing, and there's their signature, Your Honor, and it's all over their pleadings. They're protecting their ass for something else, and I've brought it in and made it bad for them. There's a concept in the law: never volunteer. Because when you volunteer, you take on all the rights that someone can reasonably expect for you for this new task or duty. So when you volunteer for something in the law, you're taking on a duty. Now you have a duty to someone, and now you can breach that duty by not foreseeably acting the way you should have. And it's law school stuff, but they volunteer to cover their ass in another area, and it opens up another problem for them. So I go in where there's the other problem. I do something that no other firm does. I file a counterclaim against Citibank as debt collectors. This drives them crazy. All this is online at collectionstopper.com. Go to my podcast plus and look at my notes. It'll be saved under Citibank securitized answer, Citibank securitized counterclaim, Citibank lawsuit. This is a rather limited amount of securitization information, but I have to do it this way, in a sense spoon feed, because if you haven't checked out already, you will check out soon. But again, really this all gets down to the concept of assignments. Securitization is really just going right back to assignments. Nobody denies it was securitized. Eventually they admit it's securitized, but then they'll go, and JP Morgan does this too. They're going crazy right now over me. They'll say, yeah, but we gave it back. Then you've got to show an assignment. It's a thing. And by the way, you're going to hear from the other side going, oh, we just securitized the receivables. All right, so you admit you broke the debt up. So who is suing my client? The guy that owns the debt, the indebtedness, the servicing rights? Because those are all broken down, all the receivables. So by virtue of the fact that even if they admit, I know you're going to get lost, just hang in there with me. If only the receivables are securitized. By the way, I don't know how that helps the bottom line of Citibank, unless it's that receivables that are dragging their credit rating down. So you're admitting that the debt was broken up. So who's suing my client and for what? you just make enough noise like that and you've got a win, even if it goes all the way to the jury. They'll take you to what's called a motion summary. A motion for summary disposition kills cases. Judges want to do that to get it off their docket. Give them a reason, they'll do it. You can turn it around. I turn it around and give them a reason to give me the summary disposition. This is a good reason that you have to start from day one. So this has to be in your answer, this concept. Look at my paperwork the way I do it and then form to your own state rules. But I'm loosening the lid for you, and you can turn it all away with this concept of securitization. Every time I do a search on securitization, it gets better and better as far as how broad the education is out there for us. It's in a good place right now. So this, in closing, is really all just about an assignment. It was assigned to a secure trust. It's got to show it was assigned back. They won't, they can't, it just is impossible. And you've got to show this. It's in their own writing, and that's another thing I always teach. You can use their own writing. They'll eventually admit that it was securitized, but it was receivables, or but we gave it back. Well, they have to assign it a certain way according to the trust, and they can't produce that assignment. Everything I teach is about missing assignments. It's no different in these cases. I admit to you right now that I'm sure I've lost a lot of you, but if you just hang in there and look at the concept, you'll see how valuable. Go to my website, collectionstopper.com, podcast plus. This is the securitization I've hinted about, and I will continue to do that and add more information. I thought rather than bore the hell out of you, I would use an actual case of mine that I'm using, and it's working. This actual case, by the way, is the one where they said, okay, we're just going to do a motion to compel arbitration. A quick tip about motion to compel arbitration. If somebody has litigated a case heavily, they don't have the right to then go, well, because it does say in the contract you can arbitrate a case, and you should arbitrate the case if either party agrees to do that. But if you've litigated the case, you waive your rights to arbitrate a case, because you just literally just litigated an answer, a counterclaim, and you said nothing about arbitration, and now you want arbitration. I'm going to win that, and now they're in trouble, because if they, it's all, at least for me, it's all about responses. How does somebody respond to your new unique approach? Now you look at that response, and they'll give stuff away, or they'll say they have a duty to do something, and you'll go, oh, but they breached that duty. It's all about this response. So your God-given talents, you have this uniqueness. I'm crazy uniqueness, and I'm not afraid to go into areas that I believe in. I believe in myself. So believe in whatever that great talent of yours is, and use it in this niche of yours, and look at the response. The response is so rich with things, and you go, why would they do that if X, Y, Z? It's all about the responses. And don't be afraid if you come up with something unique that it's going to be a slog, as I say. It's not going to be overnight where they go, okay, I guess you got us. Because they may be thinking, if he gets us, then they've all got us. I've got a sneaking suspicion that the securitization, honestly, is the end of debt collection. I know that sounds crazy. I believe it's the end of debt collection if the right stuff gets out of there. Because no one's not going to want, the securitization is actually good for America. If a business is able to produce more money to lend out to Americans, the interest rates, because there's so much more money there, are lower, and more people have access to the credit that they can pay off and when they buy a house. So securitization conceptually is a good thing, but don't be suing my client and saying you own something you don't. And what am I doing? Securitization is a benefit to the consumer, but it's also a duty now that they have to uphold and do properly. You got to see it conceptually like that. The levels, it's dropping a legal pebble into a pond, and the beauty of the ripples, that's where the rewards are, in those ripples before they hit the shore. Just drop, watch the ripple response, and you'll do fine. I hope I've done fine for you. Comment on something if I didn't touch it the way you wanted me to, or you want me to go somewhere else, or you have just a whole inquiry that you go, I wish you'd do a video on that. As I always say, and I try to remember them on podcasts, and I touch my finger to my temple, I've got 30 years in here. I can give you 30 minutes. In fact, it's rare where I give you 30 minutes. It's usually 40 or 50. What are we at? We're at 35. I thought I'd do it at 30. Comment, like, subscribe, but ask me. And I'm going to be doing classes where I teach this stuff for free. I want to see if I'm any good at it. If I'm not, so if you want to call me or email me and set up something where I teach you for 15 minutes, or you just have questions for 15 minutes, I'm going to then be asking you to tell me what I did right or did wrong before I go charging people, if I want to do that. So I'm available. This stuff, you're not paying me or anything. I've fought these guys for a long time. We need more warriors. And we need, when somebody else gets involved, they'll see stuff that I can't see. And then if you share that, we'll all do in this together and we can share. But I think securitization basically is the death knell for today's concept of debt collection. The only problem with that is that you're dealing with judges and lawyers that are a little set in cement. So your job is to educate them. And don't be frustrated because they only believe one thing. And a lot of times I'm always of the opinion that my stuff gets in the way. It doesn't get in the way of due process, but it gets in the way of somebody saying, I got to clear my docket. It gets in the way of someone saying, I'm going away for the weekend. I don't have to answer this motion. I'm always in the way of somebody. You be that speed bump stopping them from eliminating due process and putting your client into a judgment. Be the speed bump today. All right, enough said. Go look up securitization, like, subscribe, help me do this thing, and we'll do it together. Thank you very much for your time.